Good morning and welcome to our webinar, Protecting Your Business, How to Avoid Common Contract Traps. My name is Marcella Mandeville and I am Chief Operating Officer with Alberta Women Entrepreneurs. This program is brought to you as part of our Connecting to Contracts program, which helps established women-owned businesses access corporate and government contracts and new markets in Canada and around the world. The program is offered across Western Canada by the Women's Enterprise Initiative. The Women's Enterprise Initiative partners are the Women's Enterprise Centre of British Columbia, the Alberta Women Entrepreneurs, the Women Entrepreneurs of Saskatchewan, and the Women's Enterprise Centre of Manitoba. So welcome on behalf of all of the partners of the Connecting to Contracts program. Our organization, Alberta Women Entrepreneurs, is focused on helping women in Alberta, similarly to our partner organizations across the other provinces. We offer a variety of business services and financing for women-owned businesses. If you'd like any information about our programs or any other projects, please feel free to visit our websites. So the competitive advantage of being part of the Connecting to Contracts program include market building, business growth workshops, and the We Connect Canada certification. One of our guest speakers today, Christina Forth-Matthews, is We Connect Canada certified. So before we get started, I would like to introduce our guest speakers for today. Our first guest is Christina Forth-Matthews. She's the owner of AOG International, a freight logistics company in Leduc, Alberta. She is We Connect Canada certified and has won contracts with oil and gas companies in Alberta, and she has recently opened an office in Houston and is pursuing U.S. business. Our second guest is legal expert Wendi Crowe. She's a business lawyer and partner in the Edmonton office of Miller Thompson. Her practice focuses on tax, mergers and acquisitions, trusts, and estate planning. Wendi advises clients at all stages of business life cycle, including incorporation and initial ownership structure, shareholder and partnership agreements, compensation issues including employee profit-sharing plans and stock options, acquisitions and divestitures, estate freezes, and other restructuring. So welcome to our guests, and with that, I will turn it over to Wendi Crowe, our legal expert, who will be sharing how to avoid common contract traps.
Thanks, Marcella. So the first slide is already there. Let's jump right in so that we can get through a bunch of material. As Marcella mentioned, the title for today is about avoiding common contract traps. I'm sure everyone knows that contracts are a fundamental part of every business, and they're really how business gets done. So today our goal is to give you some tools to improve the contracts that you enter into and to help protect your business against the unexpected. And that applies whether you're contracting with customers or suppliers or employees, consultants. Really those possibilities are endless, but really understanding the fundamentals of contracts should help save you some money and some headaches. Our focus is going to be on common mistakes that I've seen in my practice and generally that people tend to make when they're writing contracts. And we've divided that into 4 headings, which are up on the screen. So we're going to talk a little bit about just the basics of contract law to give you those fundamentals. We'll spend a bit of time on some negotiating tips, particularly when you're getting into a negotiation with a larger, more established entity on the other side of the contract. We're going to talk about some key terms in contracts that you should be aware of. And lastly, we'll spend a little bit of time on the boilerplate provisions that many people ignore in the contract because they're tucked away at the end, but they really are quite important. So I have here a definition that I made up of what a contract is. I was quite happy. Last night I dug out my law dictionary from law school, and the definition I found there was almost exactly what I wrote on the slide without looking, so that was good. But really, the essence of a contract is, of course, an agreement, and that's a private agreement between at least 2 parties who intend to create legally enforceable obligations. And the distinction I want to make there is really between a contract and an agreement and just the general law that everyone's aware of in terms of say, torts or wrongdoings or restitution and those types of things where the law will give you a remedy. For example, if someone runs you over with their car, because that's wrong, and there doesn't have to be any agreement about that. That's just the general law. But when we get into contracts, we really are focused on the freedom of the parties to make the contract. And so that's one of the fundamentals that I wanted to mention, is that our legal system gives parties the freedom to contract, and you can make the contracts you want. The other side of that double-edged sword is that the law won't protect you or won't help you modify a contract if you made the deal and it turns out that it's not really fair, or maybe it's a little one-sided. So that's where the old caveat emptor comes in, and people are familiar with that buyer beware concept, and that's a big part of freedom to contract. We do have some limitations on the freedom to contract. For example, businesses that are subject to regulation where the government in one manner or another has deemed that there needs to be some restrictions placed on how those businesses enter into agreements. Much of our limitation on freedom to contract is driven by public policy and in most cases consumer protection, such as the Fair Trading Act, which governs a lot of how businesses can carry on and will, in some cases, void contracts or override contracts if they're not fair to consumers. So in the business-to-business sphere, you have to be aware that you don't have a lot of those protections. You do have some minimal governing law, but it is very minimal. For example, the Sale of Goods Act really speaks to if you're selling something, there's an implied representation or warranty that the thing you're selling will basically do what it's supposed to do, that it's fit for the purpose for which it's made. And that's quite limited. So that does apply business to business, and often business contracts will deal with that legislation one way or another. But beyond that, you really have to know what you're getting into. The elements really of an enforceable contract I just wanted to run through them because there are a few maybe not so obvious mistakes that people make when they enter into contracts. You need to have two or more parties, so obviously you can't make a contract with yourself. And we had some very interesting case law from hundreds of years ago as to whether you could in fact make a contract with a corporation of which you were the sole owner or director, and you certainly can do that. But the mistake that I see too often in business contracts is that incorporated businesses will sometimes include their individual directors or owners as parties to the contract. And you need to be very careful about that, obviously, because you may be defeating the whole purpose for incorporating, which is to shield yourself from liability and obligations in the business. So that's one of the things that I do see sometimes. You need to have an intention to contract in order for that to be enforceable. And the reason I mention that, normally it goes without saying, if you have a written document and two parties have signed it, that's, you're pretty sure you have an intention to contract. But we do sign documents sometimes in the business sphere that aren't intended to be binding. We have letters of intent or term sheets sometimes and memorandums of understanding and those types of documents, which are really just a basis for further discussion and developing the business relationship. So you need to be careful when you're entering into those. I say you need to get advice even on those when they're not intended to be binding. Quite often they do include one or two clauses, so the bulk of it's not binding, but there'll be a non-competition clause in there, a confidentiality clause in there that is stated to be specifically binding. And I just had a case recently where my clients spent what they would say too much legal fees trying to get out of a joint venture that really didn't go anywhere, but there was a letter of intent that included a binding non-compete provision. And my clients were the ones that had contributed some software development and some work to that, and lo and behold, they were not clearly entitled to just, the other party wasn't doing what he was supposed to do. They weren't clearly entitled to just take what they'd put in and walk away. So that's the reason I mentioned that one. We talk in contract law about offer and acceptance, and that's, again, when you're signing a document at the same time and two parties, we don't usually think about offer on one side and acceptance by the other side, but that's essentially, when it comes down to it, what you need to have. And that flows into the discussion of consideration, which is essentially anything that one party does that the other party derives some benefit from. And that needs to flow both ways in the contract. So, you may have money flowing one way and services or product flowing the other way is the most common. And the key to know there is that the law, again, will not support you if your argument is that the consideration was uneven, or that, you obviously didn't get what you bargained for because the consideration was too small for what's expected. And that just doesn't fly. As long as there's any consideration at all, then the contract will be binding if it goes both ways. The parties to the contract need to be ad idem, we say in Latin. We try not to speak Latin too much around the office, but ad idem is one of those phrases that really encapsulates what we think about as the meeting of the minds, and that means the parties have to have intended the same thing when they enter into the contract. And there's a whole doctrine of law about mistakes when entering contracts, and we won't get into that, but you do need to have that meeting of the minds to make an enforceable contract. It is very difficult, though, to come back later in the face of a written document and try and argue that that's not really what you meant. And so I'll talk about that a little bit in a minute. The terms of the contract need to be certain, which means they need to be clear and complete. And I will harp on this a little bit over and over because that's probably the biggest problem that I see with contracts where if they're poorly drafted or if there hasn't been enough thought put into it, is we have terms that are missing or terms that really aren't clear to someone who wasn't involved in the discussions around when the contract was written. So a contract can be void for uncertainty, but it's more likely that there's just going to be a difficulty interpreting it and some uncertainty about what is really meant by the contract. I wanted to talk specifically about the parole evidence rule, and this is coming back again to making sure that the contract is complete. So not all contracts have to be in writing. It's perfectly acceptable to make contracts orally, except in very limited circumstances like the sale of land where there are specific writing requirements. But an oral contract is enforceable. The problem is, oftentimes, once you put part of the contract in writing, it's very important to have all of the contract in writing. And the reason for that is this body of law that's really represented by the parole evidence rule, and that is that if you have a document which is a representation of the contract, and you end up fighting over that in court, the court will not hear any evidence about what happened beyond the four corners of the document which contradicts what's written in the document or which adds to or changes what's in the document. So extrinsic evidence is not going to be admissible, and the way that comes out in practice is if something's not in the contract, you won't be able to get a remedy for it or get your rights enforced. And this is one of the most common traps and mistakes that I see all the time. And you know, if you go to your lawyer and you're saying, well, this, the lawyer's going to ask you, I'm having a problem, well, what does the contract say? And if the answer is, well, here it is, but before we signed it, we talked about this and we talked about that, and they said it would be a little bit differently, or the person I was making the agreement with just said, well, that's standard, but here's how we're going to carry out the contract, and that's the biggest trap there is, because you need to be able to point to the written words to explain what your contract is.
Excellent. Thank you, Wendi. So with that, we're going to ask our other guest, Christina Forth Matthews, to maybe let us know a little bit about her experience. Have you ever entered an agreement without a written contract, and what was that experience like for you?
Yes, we did enter into a contract with the company. I do agree with a few things that Wendi touched on. People come and go nowadays, I hate to say, and the relationship that you have with one individual might change as they walk out the door, and you might have a new president that you're dealing with who has a different vision. So I think having things black and white, what your responsibilities are, having a contract in place, especially when you're dealing with a top-end customer that could potentially affect your company. Those are very important things, I think. To me, I always look at a contract as a roadmap, how we're going to get there, answering the 5 W's, to stop and evaluate, what are the payment terms, when do they want their product delivered. I think having the 5 W's also is very important having in a contract as well.
Thanks, Christina.
Okay, let's move on to a little bit about negotiation. One thing that one of my mentors taught me very early on in negotiating contracts is there is no such thing as a level playing field. And you need to go into every negotiation with an understanding of who really wants the contract more. And that's not necessarily, that the smaller entity or, versus the bigger entity or those kinds of things. There can be very critical contracts and very critical terms of contracts that each party needs to get. And the question in every negotiation, is really who's willing to budge and who's willing to give up certain benefits or take on certain obligations, and how do you strategize and do that. So the point I just wanted to make was that you need to know your bottom line going into the negotiation. Price is not the only thing that's variable. There's a lot of the terms that we'll talk about in a few minutes. The function of those terms of the contract is really to allocate the risk between the parties of unexpected events, or what happens and who's going to bear the risk of that in the contract. So you need to identify and then quantify the risks and the rewards for yourself in the contract. You need to do your due diligence before you start negotiating. One of the mistakes I would call it that people make is kind of getting the bare business deal done, having that conversation and the discussion with the frontline people on the other side of the deal, and then not really allocating enough time and enough resources between, scratching that out on the napkin, right, to actually getting the contract done. And there is a risk, and many times, the bigger players won't start any work until the contract is signed. Sometimes, I don't know if that's risky, but it's also risky to start doing work before the contract is signed, obviously. So you need to allow enough time to get your business deal in place and then to have the contract properly drafted. So that negotiation process can take quite a while in some cases, and sometimes it's pretty quick, but it's almost always more time and resources than people anticipate, in my experience. Let's move on. We'll get into some of the key terms in a few minutes. But one of the other things I wanted to highlight in negotiating is this idea of a standard contract or a standard clause, because I hear that all the time, and really that doesn't mean anything to me. There definitely can be industry norms as to the way certain businesses will allocate risk and determine pricing and other types of pieces of the contract. There can also be, especially with bigger organizations, internal corporate policies, such as we always have to have a 30-day termination clause in all of our contracts. And so there's things like that that you may get informed, are standard, but that doesn't necessarily mean it works for you, and it doesn't mean that it needs to work for you, but you may have to be in a position, if you're going to accept that, to get something else in return. And that really comes down to one of the other tips, I guess, I would have, which and mistakes that people may come in to look at it the other way, is doing the negotiation in a piecemeal sort of way, so that you think you've agreed on some terms and maybe you've made some compromises up front, And then you see the contract, and there's a whole bunch of other things in there that really creates risk for you or adds cost for you and wasn't built into your initial model or understanding of what you thought you were getting. And it is very difficult late in the day to go back and say, you know, geez, you're asking me for this indemnity or this representation, and that's going to cost you more money. And you know, partners in business don't really want to hear it that way. It's difficult then to build that into your pricing structure for sure. So that's really all I would say about that, is that you need to, first of all, understand. Don't skip over something because someone tells you it's standard. You still need to understand what it means. If you can't do the contract on that basis, you need to go back to the drawing board, and obviously you need to set your prices according to all the rest of the terms that are in the contract.
Yeah, I think it's important to fully understand what you're signing. There's been situations too for us where, insurance is something that they wanted covered in a contract. So you do have to make sure that you do have all those costs covered as well, what you're taking on as a liability.
Right. Yeah, I agree. I see that quite a bit. The insurance is a big one, and that's something which will often come very late in the day. Oh, here you go, we need, $2 million or $5 million worth of insurance for you to come on our site. And sometimes the insurance clauses, and that's getting down to some nitty-gritty, but I always tell my clients to send that to their insurance advisor and see if your policy actually has those provisions in it, because a lot of times they'll be drafted in a way that really you can't buy insurance that actually does that, or it's much more expensive to have the kinds of notice provisions or those extra limits that they're asking for. So that's a good example.
Yeah.
Okay. There we go. Okay, so let's talk about some of the key terms of contracts, and here I mean outside of your basic what's on this slide, which is the 5 W's that Christina was talking about, the who, what, when, where, and instead of why, you're probably talking about how much in a business contract. But you have those which I would call the inner circle, or the key, business terms of the contract. And I mentioned before, I'll say again, you need to make sure that those things are clear and complete. But you will usually, if you've seen any number of contracts, you'll see that there's a whole bunch of other terms that end up in a contract that aren't strictly related to the product or the service or the price. And so let's talk about some of those. Confidentiality clauses are very common, and that's because when you get into business, there's a necessary but sometimes risky exchange of information. And this often comes up right up front because you need to disclose some information to make the sale or to get the contract, and you have to do that in such a way as without giving your product away. So you have to, I think you understand what I mean. That's a delicate balance sometimes. But what that means is you do need to think in some contracts, and critical ones where you're going to be disclosing a lot of sensitive information, it's sometimes beneficial to have a confidentiality or a non-disclosure agreement up front before you even enter the discussion and the negotiation. And that depends a lot on what your business is like. I have a client who has, they're in technology, and they've protected their the valuable assets mainly as trade secrets, and so they need to be very, very careful about even talking to the big players in the world about what they can do and showing them around their plant site and their research labs, because there's a whole lot to be lost there. So they always sign an NDA before they even start discussions. The other thing I just would mention about a confidentiality agreement, whether it's a separate agreement or just a clause within a contract, is that it's not a guarantee. It's meant to give you some remedies if somebody goes offside. It's more useful as waving the flag to say, we're being careful about our information, and we want our other party to the contract to also be careful about that. But you really do need to just take practical steps to protect your information. Just be careful, where the email attachments are going and the distribution of copies of things, and just keeping pieces of the most sensitive information separate from other stuff. And that's just common sense. So the confidentiality clause, I guess, is also a double-edged sword, because you probably need it if you're exchanging information, but you really shouldn't rely entirely on it. I mentioned once, I think, before about non-compete agreements, and I will generally call these restrictive covenants, which are broader than just non-competes, but generally in that vein where one party is agreeing not to conduct themselves in a certain way at the risk of harming the other party. So those can be non-compete agreements, or agreeing not to solicit customers or employees or to use confidential information. And they're usually limited in some way by time frame and sometimes by geography as well. Again, these are sometimes in a separate agreement entirely, or sometimes they're just buried within the contract. And like I mentioned, my poor clients with their letter of intent, it was sort of tucked away in there, and they ended up having to do some work to get where they wanted to be with it after. So these are very common when the contract you're looking at is in the nature of a joint venture, or even some types of manufacturing and distribution agreements, franchise agreements. Those kinds of agreements are really where you'll see the non-competes.
Sorry to just interrupt for 1 second. For those of you that are joining us by telephone, if you could please mute your line. We're getting a lot of feedback at the moment, so please mute your lines if you are joining us by telephone. Thank you. Sorry, Wendy.
That's okay.
Please continue.
No. Yeah, so just on restrictive covenants, I would say, that there's two traps really. One is not realizing how broad they are. So it sometimes is not just you can't directly compete, but it's all about sometimes using information as well as talking to customers and employees of the other party. The other trap is not thinking about this at all when you really should, in terms of the type of relationship you're entering into, and do you need a non-compete to protect your own business? Clearly, when you're dealing with maybe hiring consultants and giving them information, or employees or independent contractors, and those types of arrangements are where these usually come up. I mentioned here the ownership of work product, which is often dealt with in some types of contracts, and that is just whether, what is the other party buying from you if they're a customer. Is it just a license to use your information, or is it an outright sale of some product or service? And then where we get into some complexities is, if it is say a new method of doing something, or some advice that you're giving in your contract, what if your customer then makes some improvements or some modifications to that, and who owns that, and who ought to have the benefit of that? So that can be a very complex area, but it's just one to be aware of, because it is often missed entirely in contracts that I see, where it just didn't occur to someone that they might need to specify that. Okay, representations and warranties we see in almost every contract, and sometimes they speak to things like just basically the ability of each party to enter the contract, that you have the right authority to do that. But a lot of times they'll go beyond that as to certain qualifications or certain aspects of the product or the service that's being provided. So they can be quite critical in contracts. You need to think in every case about whether the arrangement you're entering into is in reliance on some representations that have been made to you, and so do you need representations from the other party in the contract? Remember, again, the parole evidence rule says that if you don't get it in writing, and it was just something that crossed by way of email or conversation outside the contract, then finding out later that representation was not true, or that there's a warranty that's been breached, you won't be able to get a remedy for that. Termination provisions in contracts are very important, obviously. Some contracts will be set up so that they're for a fixed period of time or just for a fixed deliverable, but a lot of them now will have an automatic renewal or the ability on one party or the other to extend the contract or renew the contract. So there always needs to be some thought given as to the mechanics of how that can be done, the timing for doing that, and if it's an extension or renewal. On the other side, if it's a provision for early termination, again, what are the mechanics of doing that? But more importantly, what are the events or the circumstances that give rise to the right to do that? And to take it one step further, if that happens, if the contract is terminated early, what are each party's rights at that time? Is there a right to lump sum payment, for example, or is there a right simply to terminate the contract, or does that also give rise to some other remedies?
Also, too, I think just to add, the payment terms, what does that look like now? I think it's a different separation, I think,
right,
than the actual contract part.
Yeah. Okay, I have another slide specifically about remedies for a default in a contract or a breach of contract. And one of those common remedies that you'll see put in is that, if someone's not holding up their end of the deal, we can terminate the contract and do that, on a specific notice period. But, there may also have been some loss that flowed from the failure to carry out the contract. And that's where the contract will sometimes provide for what we call specific performance, which is very rare and is not often enforceable in some cases. And that's where the remedy would be to go to a court and actually get an order for someone to do what they were supposed to do under the contract. For business contracts, other than the sale of land, like I said, that's very rare. So usually your remedy, you may be entitled to terminate the contract, and you're usually entitled to sue for damages. There can be different types of damages, and I won't get into the details there, but damages is usually how the law addresses someone not carrying out the promises that they made. Now, you may also want to provide in the contract a specific right of set-off. So if there are monies owing both ways at any time, or if there's even another contract that money might be owing on, and there's something wrong with a different contract, so you may want to contractually have the right to deduct and set off the losses for one breach against what's owed on another contract. And as the party who might be subject to that, you want to be careful that you don't give that up too easily, obviously, because you may need your day in court, to prove that the breach didn't result in that loss or something. So the set-off is really almost like an advance right to collect your damages. And it's not always appropriate, but if it's intended, it does need to be stated in the contract, because a court will usually be quite reluctant to allow a set-off unless it's been specifically agreed. Quite often a contract, especially a more complex one, will provide for specific indemnities as a remedy for a default. And I'll talk about those specifically. Actually, let's just go here. So an indemnity, a lot of people find these very confusing and don't understand them. And again, the tendency is to skip over it and say, oh, that's our standard indemnity, or that must be all the, the legalese. But it's very important to understand what the indemnity does. So it's a contractual agreement to pay damages for some misrepresentation or a breach of contract. So, and I think we have to step back a moment just to understand what normally has to be proven in order to collect damages. So you need to prove that there was a contract, you need to prove that there was a breach or a misrepresentation in the contract, you need to prove that damages resulted from that. So all of that is the same with an indemnity. But if you don't have a contractual indemnity, the party who suffered the loss also has to prove that the damages were a foreseeable result of the breach. So there has to be that nexus or that connection between the damages and the breach. And it has to be, objectively, if I'm the one who breached the contract, the other party has to be able to prove that I ought to have known that they were going to suffer the type of loss they suffered when I breached the contract. And that can be a very difficult thing to prove, and the way we get around that in contracts is we put indemnities in the contract, which just skips over that step about foreseeability. And it says, if I suffer a loss and you breach the contract and the two are connected at all, it doesn't matter how remote that damage might have been, you will have to pay for the damage. So it's obviously very important to limit indemnities as to what types of breaches and misrepresentations are covered. Sometimes we'll limit indemnities just to a fixed dollar amount. That's not as common, but it does happen sometimes. You may want to limit the indemnity in terms of how long the other party has to make a claim. So we often will see a survival period. And in fact, one of the mistakes I see quite often are indefinite indemnities and very broad indemnities that will cover all types of damages, whether they're direct or indirect or consequential and those kinds of things. So indemnities, because they are usually quite wordy and they're a little bit just confusing to read and understand, they are an area where you should get some advice. It's a key risk area in a contract if you're being asked to grant an indemnity.
So just a quick question for Christina. Has there ever been a clause in an agreement that you wish you'd had, and maybe specify what kind of clause that was, after you had signed the contract?
Yes.
I think everyone who's done contracts has run into that. I'll decline to answer that because I'm supposed to be the one who catches everything.
Maybe just one example of a clause, a very important clause that perhaps was missed in a contract.
The payment terms, actually.
We've all been there.
I think you are so busy focusing on all the other issues and details in the contract. When you get paid is very important, and I think you need to have that in there specifically, what your terms are going to be, because that's how you pay your bills.
Excellent.
Okay, we'll go on. So let's talk about boilerplate for a minute. I know everyone will now be falling asleep or switching off, but please don't, because I mean, we hear about boilerplate, and the lawyers use that term as well, and we mean all the stuff that's very important that nobody ever really pays much attention to, and that's our job to make sure that it's complete and it's right. So generally what we're talking about are those series of relatively short little clauses at the back of the contract. They're very common and will be common across many different types of contracts. In many cases, what those clauses do is codify the law of contracts the way we understand it, and so in that sense, it may be a little bit of overkill because it's your lawyer's attempt to make sure that there's no uncertainty about certain provisions that, and I can talk about some of them in a minute, the ones that I see mistakes being made on or not enough attention being paid to. But we don't write contracts so that we can end up in court arguing over these types of provisions, and that's why they are important, and they're important that you haven't missed any of them and that it's complete. And believe me, the first thing that happens in many cases where there's a dispute over a contract is we are digging into that boilerplate to look at the mechanics of how notices are supposed to be given, or is there a requirement for what we might call further assurances? So this, we forgot to get one document signed, but it's clearly necessary to carry out the contract. Can we force the other party to sign it or to take an action that we want to do? So as soon as you're sort of butting heads and wanting to know if you can force an issue or not, the first place you're going is often to the boilerplate. And it's not always neutral. There can be things in there that favor one party over the other. So the first one, back to my parole evidence rule soapbox, is you'll see the entire agreement clause in many, many contracts. And this is an example of something that is codifying the parole evidence rule, but as with every common law rule, there are exceptions to it, and there's ways that a court might admit some evidence of what wasn't actually in the contract. And so if you, for certainty and to make sure that it's clear, we'll put this clause in that says that our written document is everything, and we're not going to get into an argument about who said what outside the contract. So that's what this clause means, and it is important to have it in just for certainty. The next one that I have up here, and these look really long once I put them on the slide. They look shorter if they're typed in the smaller font, I guess, on the contract. But this one, I think, the no waiver clause is really important, because effectively what it's saying is the fact that a party hasn't complained about you doing something wrong the first time you did it, or even the second time you did it wrong, does not preclude them from claiming their remedy if you do it wrong again. So what this says is, you can't get lazy about complying with the terms of your contract, and it will not work, if you have this clause in your contract, and if it's usually there, you won't be successful if your argument is, well, I know the contract says X, but, we've been operating under it, and we've been doing it this way for the past, so many months, and nobody's ever complained about it before. I thought that was just fine. And that that's not going to save you, because usually you've got a clause there that says, we don't have to catch you every time you mess up or you don't strictly comply with the contract, and it doesn't stop us from insisting on strict performance later.
I think that's why maybe it's important to keep your contracts up to date as well.
Yes.
I've seen contracts that have, been 5-year terms, but along the ways things change, and it's always good to go back and update.
Absolutely, yeah, I agree. Yeah, and the same, yeah, with ones that will automatically renew or extend even. There's quite often some terms that need to change on the extension or the renewal, not just pricing updates, but other things as well. Yeah, and that's very important. I listed a few of them here just that I wanted to talk about briefly. And so the notice provisions in a contract, I've mentioned those. You do need to read these and make sure that what's provided for there is actually going to work for you. And in doing that, you're thinking about when might notice need to be given under this contract. So depending on the contract, you might not foresee any kinds of notices except if there's a breach and an early termination, for example. But in other contracts, there's notices regularly back and forth all the time. And so, look at all the different methods of notice. Some of these I find are very archaic. If someone's using an older form of contract and they're just sticking in the old boilerplate that talks about registered mail and personal service, they don't even say you can courier a document to someone and that's good enough. They definitely need to be updated if you plan to deliver documents by email and fax and those kinds of things. So quite often they're out of date, and quite often they just don't work that well for the people that are actually sending and receiving notices. The governing law clause in a contract is, again, usually a codification of what the common law already says, which is that, whenever we have contracts, as we do more and more often, that cross jurisdictions, there are a whole set of rules. They're incredibly complicated to figure out which jurisdiction's law is going to govern the contract. And there's two parts to that. One is for interpreting the substantive issues and what the contract means. The second is if you need to bring an action on the contract, where do you have to do that, in which jurisdiction? And to avoid any uncertainty and having to pay lawyers to figure out what the answer is at common law, we just put a clause in the boilerplate that says, this contract is going to be governed by the law of Alberta, and any actions on it will go to the Court of Queen's Bench in Alberta. That's fine. And that's just for clarity. But what you need to be careful of is if you're doing business with an entity that has a headquarters somewhere else, watch out for contracts that say it's going to be governed by a law, a foreign law. At the very least, you may need to get advice in that jurisdiction as to certain provisions and what they mean. And you may be stuck with huge costs that you didn't anticipate if your only remedy on the contract is, to sue in Texas or in Europe somewhere. Sometimes these clauses are quite, I wouldn't say heavily negotiated, because it's usually a 50-50. You've only got two options, not always. But I have done contracts with companies overseas where we've specifically agreed to pick a neutral jurisdiction as opposed to one party or the other where their home base is. So those can get quite interesting when you're doing multi-jurisdictional contracts. Talking about costs of getting a remedy, the dispute resolution clauses can be quite important. Some of these, again, if enough attention isn't paid to them, they're too simplistic in the sense they don't really do what they're meant to do. So usually you're talking about a clause that requires the parties to go to arbitration or even mediation before they go to court. And you need to think about whether that is going to work, or is that just going to add another layer of some resolution that isn't really binding and isn't really what you want, and then so you have to go through all that, and then you have to bring a lawsuit anyway. So those can be just an added expense and time waster. For the most part, though, if they're properly drafted, they can be very beneficial to getting a result. The last one I put on there was force majeure, and that's another one just because it's people don't really understand what that means, I guess. But those clauses, if you read them, are, again, usually quite long and wordy, and what they're essentially saying is that if some external circumstances or events arise beyond the party's control, that one party, or possibly both, will be relieved from performing the contract, or at least the performance of the contract will be suspended for some period of time. And so usually what we're talking about there is, if war breaks out, or sometimes if you can talk about severe weather delays, or expropriation of property by governments, and those kinds of things. And again, if you need to assess the risk for your own business about whether you need more exits in terms of the force majeure clause, or whether if the other party is allowed not to perform, are those circumstances fair, and should they be narrowed perhaps?
Excellent. Well, I guess just a final question before we head into our conclusion. But Christina, would you ever sign an agreement with someone you didn't trust?
Absolutely not. I think it's very important that you're aware of the company that you're actually signing with, that they're reputable, what their company philosophy is, where they've been, how long have they been in business, how big are they. I think, yeah, if you don't trust, go with your gut, don't sign, or negotiate till you're comfortable.
Excellent. Thank you. Good advice.
Okay, so I guess that brings us to the end of the formal presentation. Just to reiterate again, just make sure you read all of the contract. If you don't understand it, get some advice about it. As Christina said, keep negotiating till you're comfortable. Never sign a contract with the thought in the back of your mind that, it doesn't really say everything I need it to say, or it doesn't really say what we've talked about, but, I'm sure nothing bad will happen. That's one mistake. The other mistake is say, well, yeah, I kind of got a bad feeling about this one, but I got a contract, and I'll be able to take action and get a remedy if it doesn't work out. And that, I like to think of the litigators of the world, of which I'm not one, as those are the guys that are looking at the lose-lose situation. I mean, it's not worth it. And so doing the homework up front and making sure that you're comfortable is the way to go. And it really, comparatively speaking, if you've ever been in a dispute over a contract, you will know that the cost of doing that is monumental compared to the cost of asking a few questions and just making sure it's right from the beginning.
I think it's important that if you're not comfortable and don't understand, that you ask the question to somebody else. I think it's very important. And don't feel bad about doing that either.
Yeah, and I didn't say that before, and I meant to. That one thing I see consistently with business owners who are very, very successful is, I don't know if it's a sense of the all-powerful, like I'm good at my business, so why don't I understand the contract, or I ought to? And so there's maybe a little bit of people feel like a little bit of shame in saying, like, I really can't understand this clause, and I don't really know what it means to me. And that's okay. I deal with business owners all the time who are extremely good at what they do, and the most successful ones, I like to think, are the ones that understand what they're not good at and what it's better to let someone else explain to them or deal with. So yeah, that's for sure.
Excellent. Well, that wraps up the formal portion. So if anyone has questions, please feel free to use the chat function in the webinar to ask us any questions that you might have for our guest experts. We still have a few minutes, and we welcome any questions that you have. In the meantime, while we wait for some questions to come in, I just would like to mention that the slides will be available to those who did attend today. We have also recorded the session today, so we will be sending an email link with the formal part of the presentation for you to be able to enjoy over and over again. And I'd like to invite you to learn more about our organizations, the Women Enterprise Initiative, and to join us, AWE, Alberta Women Entrepreneurs, at our Leadership Summit and Celebration of Achievement on May 9th. So I had to get a plug in there for that one. But it's a great day of capacity building around leadership for anyone who's interested in attending. So feel free to visit our website for more info on that session. So I have a question for our experts while I still have them here for a couple of minutes. Christina, what difference are you seeing between putting contracts together in the U.S. and Canada? I know this is a big question, but maybe just if there's one clause or something in particular that you're seeing is considerably different with the work that you're now doing in Texas.
I think the most important touch for us would be the jurisdiction and picking where that would be. If something did go wrong and arise, would it be in Canada? Would it be in the U.S.? So I think that's a bit of a challenge because it is a huge cost attached to that.
Right, and not that the cost of any kind of jurisdiction, and not that it's not scary to go to the courthouse here in Edmonton, but there's certainly an added layer of unknown when you're going to be subject to the decision or the rules of another jurisdiction.
Like for us, there's been contract agreements where it's been talk of Houston, Texas. Well, for that means flights, hotel, finding a good lawyer down there, and having those discussions, right?
So yeah, I guess that's a question for Wendi. If questions come in following that. Do you need a U.S. lawyer?
If the contract is governed by somewhere other than Alberta, then I can't give you advice about it, right? As an Alberta lawyer, my insurance only lasts as far as the border. So, it's not to say that I have clients all the time that, may end up negotiating a contract, and we'll go through the negotiation, and we may try and pull that governing law clause back to Alberta. But if we're not successful in doing that, then a business decision has to be made, as to whether you want to go and just have that contract or certain pieces of it reviewed by a lawyer in the jurisdiction that it's going to be governed by. Because Within North America, our contract law generally is fairly well known, and we can spot some issues. But to actually give you a legal opinion about what your risks are, you do need local advice.
Okay, wow. Well, we do have some questions that have come into our questions section. I apologize if there was a delay, if anybody answered questions earlier or asked questions earlier, but we have a question here on what is the position on the corporate veil if you are the only director of your company and there are no other employees either? Good question. Wendi.
Excellent. Okay, the corporate veil. So this person's done a little bit of reading, maybe. Corporate veil is that shield that we talked about, and I mentioned it in terms of the reason you would incorporate your business is to have that veil or that shield between the individual owners and the corporation. So to answer the question specifically, the fact that there's only one director or only one shareholder of a company does not pierce the corporate veil, as we say. But you do need to be careful, again, that you don't inadvertently get added as an individual party to a contract, so you're bound by it individually. And also that you are conducting yourself in a way that doesn't allow obligations and liabilities to leak through that corporate veil. So that's everything in terms of making sure that your corporate name is on your contracts and your invoices and your business cards and all of those kinds of things. So it's a course of conduct that ensures that you don't lose the corporate veil. But certainly having only one shareholder and one director, you still have that available to you as long as you don't do anything to ruin it.
Okay, all right. And we have another question. It's a long one. Oh my. I think some of these questions we may need to answer offline. So apologies if you have submitted some questions and we're going to run out of time to get to them. But there is a question here about how does the peril evidence rule work with implied representation or misrepresentation? Wow, these are complex questions.
Is this the law class that's signing
wow. The question is, does this mean parties have no recourse for these breaches?
That's a very good question. And it's not to say that there's no recourse. I guess in the time we have, I would just say that the parole evidence rule is there, and the court will uphold that, and by that I mean will limit the evidence that you can call in terms of what discussions and negotiations were had outside the contract. But if the contract has gaps in it, there is some other body of law that allows the court to infer, you mentioned implied representation. So the court will sometimes look at if the contract is half empty or if it's lacking, was there some reasonable expectation of the parties in this case? And that's always a balancing act between that parole evidence rule and some inference of what those expectations were. But when you're down to actually calling evidence, you can bet that it will be limited if you're trying to have this discussion about oral conversations and those kinds of things.
Great. So I see we've got 1 minute left. So our final question, and again I apologize if we missed any questions, but we will do our best to get our answers to you, participants. Last question in 30 seconds. Is arbitration legally binding?
So the answer in 30 seconds, 1 second is sometimes. So, I mean, you can, if you agree to go to arbitration, you would hopefully specify ahead of time whether that's going to be binding or not. So usually a properly drafted arbitration clause in a contract will say that that decision will be final and there won't be a bunch of appeals to the courts. But again, that's a subject for negotiation.
Excellent. Do we have time for a 15-second question? All right. Here's the question. How do you pick a lawyer that is right for you in your business? I think this is a huge question. And Christina, in 15 seconds, how did you pick a lawyer that was right for you in your business?
I think the knowledge, what they specialize in a certain field, I find lawyers sometimes get a little bit more deeper in a certain aspect of things. So if you're looking for a certain thing like contracts, make sure that they understand them, they do them daily, and they're comfortable with them. Going to a lawyer that has no idea and has done one once a year is not a good idea. So source well, ask questions.
Excellent, thank you. Well, that concludes our webinar for today. Thank you very much for joining us today, and we hope you will join us for our next webinar, to be determined when and what that topic will be. We will be setting an evaluation, so we look forward to your comments on the webinar and your ideas on future topics. And we wish you a very great day. Thank you again, Christina and Wendi, for your wonderful expertise. Goodbye.